the telephone?
Isn't that speculation?
No, my lady. The fact is that his personal phone was on. It was picked up at 8:26 on the day in question. Beg your pardon, it was 8:46. And it's indicative of the fact that he was not
when
trying...
he sent a message to Madam X, was it?
No, it was an Exhibit Double D, my lady, at 8:46.
We know that he sent a message on his, I presume, his personal phone to her early in the morning.
He did communicate with her. But the fact is, he had a second phone. It was on. It wasn't switched off. And we say that the inference to be drawn is that he wasn't trying to conceal his movements from the world at large, and he was simply trying to conceal his activities in the morning from the deceased. But lady, then I wish to deal with certain aspects relating to the conduct of the investigating officer and him as a witness. I don't want to belabor it, but I want to refer to it because it's indicative of the type of investigation that was carried out. It's indicative of the fact that the process was targeted significantly against the accused without being an even-handed investigation. And I've referred to the fact that the stewards who were present in the house, if ever there was a starting point, they were in the flatlet at the back of the property. No attempts were made to take affidavits from them to indicate whether they'd heard any commotion. It subsequently emerged that they were interviewed and they said they heard nothing, so seemingly because it didn't assist in the case against the accused, no affidavits were taken. The information relating to what Mr. Gray saw at the corner of Titus and Lucius Way, I submit, is significant in the sense that the car is there, there's initially nobody at the car, there's a gate that's open. Subsequently, this person is seen to get into the green BMW, and this incident with Mr. Gray happens. The follow-up of that, I would have thought, was also important to the investigator, to find out who lived at that house. Did they know the accused? Did they know anybody who was with a green car who might have visited? Significant aspect of the investigation, which was not followed up, despite the prosecutor's request in the investigation diary.
I thought that they said they had been there.
Beg your pardon?
I thought they said they had been there.
Nothing is in the investigation diary in answer. There's no statement from anybody.
Did Sonnenberg not testify that he'd been
He
there?
referred to the fact that somebody was sent there, indeed, and they found that the people didn't really know anything. But that's an important aspect. If one reads this docket, it's an important aspect that should have been followed up, and it wasn't followed up. Again, I referred to the fact that they have this affidavit from Mr. Thomas the day after the event describing the driver of the Audi. No steps are taken to put together an identikit, which would be the obvious thing to have done. That was never explained. Taryn Steed referred through her photographic reconstruction or the CCTV footage that she saw. She referred to the driver of the green BMW without number plates as having worn a light blue golf shirt. Thomas described a peak cap worn by the coloured male driving the Audi as having a black top and a red peak.
I thought the top of the cap was black and the bottom of the cap was red.
Yes, that's right, a black top and a red peak to the cap.
Okay.
And in his evidence, it seems that no attempts were made to search for this or to find clothing fitting this description. And significantly, my lady, the evidence relating to access to the vehicle, I submit, is very telling, because very damaging evidence was given in that regard. And I submit that it was misleading evidence. The suggestion was made, or the direct evidence was given by the investigator, that the accused had been refusing requests for access to the vehicle and that a court order had to be obtained to obtain the access. In his words, in the investigator's words, we did ask numerous times for the vehicle, and then the Wynberg court ordered that the vehicle be given to us for investigation. You then asked why it was necessary for it to be ordered, and he said because we were asking the whole time and they didn't give us the vehicle. And milady, if regard is had to Exhibit Double H, which is the record of the court appearance in Wynberg Court on the 8th of May 2018, one sees that Mr. Mathewson is in court Prosecutor stands in for Advocate Galloway, who's not available today. Identity parade photos done and certain other information noted. And then, by agreement with the defense, one of the accused vehicles is to be handed to SAPS for tests to be conducted, and the car is then to be returned. That's what the prosecutor places on record on the 8th of May. Mr. Mathewson responds, and he says, in respect to the vehicle, same will be provided. That's placed on record in court. Subsequent to that, my lady, there is the exchange of correspondence, which is to be found in Exhibits Y1 to 3.
Apart from the fact that you would probably like the court to wrap the police over the knuckles a little bit, is there any real relevance to the case about these aspects?
Real relevance to?
To the case, about
It's
these
relevant.
aspects that you thought the police...
It's relevant, my lady, because this evidence was led with a view to incriminate the accused, to suggest that he had something to hide. He was not making the vehicle available because he was being evasive in that regard. And this evidence, which is clearly misleading, was placed on record. Fortunately, I have a very conscientious and astute attorney who wrote letters recording what had happened. And he writes, we've heard what happened on the 8th of May in court. He writes in Exhibit Y1. And this is on the 6th of July. He writes to Advocate Galloway, my colleague in court. And
You don't have to tell me that.
I'm not reminding you that, for the sake of the record, my lady, in case this is read. We do know who she is.
I remember that.
He says, Dear Advocate Galloway, we refer to the above mentioned in our telephonic discussion and wish to place on record the following. Since the court appearance on 8 May, nobody has contacted our client regarding the Audi Q5. As you are aware, our client is now unemployed and his employment was terminated as a result of this matter. He's not financially able to continue to pay the monthly installment on this vehicle. The Audi will accordingly now be sold. Should you have any queries, please do not hesitate to contact the writer. And then a further letter is written plainly in response to what was communicated there, also to Advocate Galloway on the 6th of July, relating to the vehicle under the heading Audi Q5. This is Y2, my lady, where he says, our office has now been contacted by Sergeant Sonnenberg from Diep River Police Station, who assists in the investigation of this matter. He requests the Audi Q5 be made available for further investigation. We are not opposed to such an application and will give our fullest cooperation. We will, however, kindly request that the process be done as speedily as possible. This is the only vehicle that Mr. Packham has, and we would appreciate it if arrangements could be made for his legal representatives to be present when this investigation is done. It would further be appreciated if a date and time could be arranged and the vehicle not stored for a long time, etc. Cooperative to the nth degree, my lady. And then finally in Exhibit Y3, again a letter from Mr. Mathewson to Advocate Galloway, this time dated 26 July. There's reference to DNA samples in the first paragraph. And then further, we confirm that our client will report to Diep River Police Station on Monday the 30th to deliver the Q5 as requested.
What
We'd
paragraph?
appreciate it.
Can you just tell me what paragraph you are at the moment?
It's the second paragraph, my lady.
Oh, no, 144, 145, 146.
This is Exhibit Y3.
And you're reading from
They're
one.
just two paragraphs, Stuart.
Very well.
We would appreciate it if this vehicle could be made available for collection before Friday the 27th of July. So that is the chain of communication following the court appearance on the 8th of May, my lady. And it's indicative of the fact that there was no reluctance at all, at any stage, to make the vehicle available. The fullest cooperation was offered both at court and in the correspondence entered into. And I make the submission, my lady, that the evidence given that he was evasive, when your ladyship heard the evidence of the investigating officer, was plainly misleading. The facts do not support that. I've referred Your Ladyship to the events when the accused was arrested at his home. The reference to all the ladies started phoning different attorneys. I'm not going to repeat that. But again, it's indicative of an attitude, an attempt to create an atmosphere unfavorable to the accused. Further attempt is made to suggest that the affidavit that the accused furnished to Twiza, Exhibit K, was a contrivance for the reason that there was no point in telling the story as the disciplinary proceedings had already been finalized. And again, milady, correspondence was entered into, and I don't intend to take you through all the detail of it, which sets the record straight, and the evidence demonstrates that the process had not yet reached finality, as the CCMA proceedings had not yet been finalized. Nothing unusual in him wanting to convey his side of the story to his employers. And we make the submission, milady, that it's clear that the investigator had the accused in his sights from the beginning, from the 23rd of February, when hostility was already conveyed or indicated to the accused. And the investigation sought to focus on building a case around the accused, not investigating the matter in an even-handed manner. And we know that on the 23rd, the investigator, when he interviewed the accused at the police station, made reference to the accused taking a lie detector or polygraph test, which was indicative of his attitude towards the accused then. And significantly, the accused was agreeable to taking such a test, but the offer was regrettably declined. So that is the atmosphere that surrounds the course of the investigation. The only further aspect that requires or warrants mention as far as the state case is concerned is the photographs taken off the CCTV footage. We have the footage at 28 Riesling Road on the morning of 22nd February, Exhibit W. The investigating officer says in his evidence that it depicts the driver at the photograph, or the footage and the photograph depict the driver as a white male wearing a white shirt. Scrutiny of those images taken from the footage reveals no such thing in our submission. And we submit that this footage and these images take the case against the accused no further. I don't know if Your Ladyship has had an opportunity to have a look at the
video. I haven't been able to open. I've asked my IT lady to come and have a look.
Yes.
That was some days ago, and it's not happened yet, but I will.
Well, certainly the stills don't convey what the investigating officer says it does, and we've looked at the footage and we don't see that it conveys what he suggests in evidence. And then there's the footage taken in Kendall Road, in the vicinity of Christie Sports. Taryn Steed testified that a comparison between the driver who drove the vehicle in the normal course to the person who was driving it on the 22nd of February demonstrated the latter driver to be a person of bigger build. It's submitted that that takes the state case no further. So that then, my lady, is my summation of what is in the state case, and I could theoretically stop there and argue it on that basis, but I'm going to take Your Ladyship to submissions relating to the defense case. We say, my lady, that the accused has been consistent in his evidence. He's provided a detailed version of his movements from the very outset. First affidavit was furnished on the 23rd of February when he was interviewed by the investigating officer and furnished a statement in Exhibit J. Subsequently, in the further statement Exhibit K, submitted to Twiza, he sets out his side of the story and gives a detailed account of his movements. And it's submitted, my lady, that from an early stage up until today and to a stage past his evidence in this court, that his version has been consistent. As to demeanour, it's submitted that he made a favourable impression as a witness. He answered questions directly. He made concessions which should fairly have been made. He didn't contradict himself, my lady.
What concessions?
He ladyship asked him whether he told his girlfriend that he had been separated, he was separated from his wife by way of example. And was that the truth? Did ladyship recall that?
No.
And he says that he did tell her. There were a number of aspects that were raised with him, such as that, where he conceded he had told untruths, but they were inconsequential. And apart from being consistent, milady, we say that his version is materially corroborated by the evidence of the state. And we say that significantly, Mr. Harvey's evidence confirms his movements on the 22nd of February, and this was an analysis was done way after the accused had already furnished affidavits J&K, setting out his movements on the day in question. The important aspect of Harvey's evidence, placing him at his sister's house until 21H18 or 9:18 on the evening of the 22nd, we've dealt with extensively with your ladyship. And the state evidence of Thomas and Steed regarding the fact that by 9 o'clock the BMW was already burning at Diep River railway station and a person was seen driving away is significant. Equally significant, my lady, is a description furnished by Thomas in his affidavit of a 30 to 35-year-old coloured male, which demonstrates that it was not and could not have been the accused driving away from the scene. In the very least, my lady, it creates reasonable doubt as to whether it was him. The evidence of Markwell as to the accused's presence in her home that evening corroborates his version. She's less precise about times, but she says he was there for dinner. The evidence about the investigating officer challenging the accused on the 23rd of February with the potential to take a lie detector test, we say is most significant when assessing the probabilities. We submit it's improbable in the extreme. Had the accused been responsible for the death of the deceased, that he would have been agreeable to taking a lie detector test the following day. Mr. and Mrs. Stewart's presence in the home on the 21st and 22nd of February we submit is significant. They were tenants in a flatlet which was part of the house and very closely connected to the access point to the garage. They would have had a clear view of activities in and around the garage access point on the day in question. And they would readily have become aware of any commotion had there been any. Clothing, milady, it's common cause that on the 22nd of February 2018, the accused had been wearing a white long-sleeved cotton shirt with the corporate branding of Twizzler on the right chest and a pair of black or dark chinos. He was seen in this clothing during the course of the day from the time he arrived at work and went to Springfield School. Paul Gray spoke of the person who boarded the BMW as wearing shorts. Taryn Steed, scrutinizing the CCTV footage, referred to the driver wearing a blue golfing top or shirt.
No, she didn't really say that. She said light colored or blue. I got the impression she said light blue, but I will have to go and look at it again. But you can continue. I will look at it again.
Lady, my recollection of her evidence is that you referred to certainly a blue coloured top. I'll just take the ladyship there. It's at page 114. The foot of the page. She says the occupant in the vehicle that was observed had a light blue or fair.
That's what I said. Light blue or fair. Fair is not blue. There's a big difference between light blue and blue. Light blue, fair is a big difference from blue. It's just in this matter there are so many aspects that hinge on words.
Well, my lady, if it's blue, whether it's light blue or dark blue, it remains blue. But I'm not going to argue that point. But that was, as I understand the evidence. Descriptions of clothing by these witnesses does not fit what's inconsistent with the description of the clothing worn by the accused on on the day in question. Calls are made to the cell phone of the deceased by the accused during the course of the day, and such conduct, we submit, my lady, would make no sense had the accused been involved in causing the death of the deceased earlier in the day. The accused was distressed during the course of the day. The state witnesses testified to the fact that at stages, when speaking to him on the phone, when he was looking for the deceased, he had been weeping over the phone. There had been progress with marriage counselling. It was common cause that they'd made good progress, and there was talk of them renewing their vows during the course of 2018. I've made submissions relating to the call to Ludovic at Twiza. I don't intend to repeat all of that, my lady. Safe to say, it's indicative of the fact that it supports the version of the accused, and it would be naive in the extreme for him to have requested Janssen van Rensburg to provide him with an alibi if indeed he'd been responsible for the death of the deceased.
But now you refer to the call, but you do not refer to the text message.
Yes. The accused explained the follow-up text message, my lady, the WhatsApp message.
Yes?
His evidence was that he had become aware that on social media and in the media generally that a version was being conveyed that was incorrect, relating to him asking the witness to provide an alibi for him to the world at large. And his reference in the WhatsApp message was to remind the witness of what their discussion had been or what his request had been. That was his explanation. And if, as testified to by the accused and conceded to by van Rensburg, his request to van Rensburg had been if Gill calls, and he was making that request after 12, he was anticipating that the deceased might still call his workplace and look for him, and he had a perception that she was alive, my lady. The disclosure at the Wynberg police station, it's not that he didn't go and report it. He went at 5:30 to the Wynberg police station to report the deceased as missing. Importantly, the disclosure he makes to Colonel Labuskaghni when he's asked, did you and your wife have an argument or a fight the night before? He says they had a fight of sorts, but it was resolved by the time she left for work. If he had a guilty frame of mind, my lady, that is something that he would have sought to hide and would not have disclosed to the police officer. And we submit on the probabilities that that disclosure is also indicative of an innocent state of mind. He had no visible injuries to his...
You do recall, of course, that there were two versions of what the argument was about the previous night.
Well, they overlapped, my lady. They were similar.
The one was about disclosure. He said it was not about disclosure.
Yes. Well, it was about whether there were feelings for the Miss X. So there was some...
How is having feelings for someone and disclosure reconcilable with, I want to go to Joburg tomorrow, and I don't want you to go to Joburg tomorrow?
A lack of trust as a result of the disclosures that had been made, my lady.
Okay.
I've dealt with the fact that the private phone remained active. I've made that submission, my lady, and that had he wished to hide his movements from the world at large, he would have switched both his phones with. I've dealt with his presence in Takai with his sister until 18 minutes past 9 on the 22nd of February, as established on the state's own version, as well as Keenan Thomas's description of the driver leaving the station at about 8:30, according to his affidavit. I've also argued before your ladyship that the accused's visit to the station, having heard of the burning vehicle, was significant on the probabilities. He would not have gone there had he been the person who was earlier seen leaving.
Mr. Webster, just the fact is that he did not go voluntarily.
He did, my lady.
No.
He didn't have to go.
There were 6 other people who pushed him into the car, basically. 6 other people who said, let's go. We could hardly have said, and on the probabilities, he could hardly have said, no, I don't want to go.
There's no indication.
He didn't go on his own.
There's no indication, my lady, that he was unwilling to go to the station. The evidence is that his sister had certain information. She and a friend came to pick him up at home. They went to Diep River Police Station. At Diep River Police Station, they received certain further information relating to a burning vehicle.
Yes.
There were other friends there. They got together in one car and they drove there. There's not an inkling on record that he was reluctant or unwilling to go there. And I submit the fact that he was willing to go there on the probabilities is very significant. Lady, we submit that there were no contradictions or inherent improbabilities in the defense version, and we submit that the evidence of the accused has presented no basis for rejection. Lady, in concluding, I want to briefly refer your ladyship to the approach to assessing the evidence. And I make the submission that the correct approach for your ladyship to follow is to critically evaluate each aspect or each component of the evidence. Make a decision as to its reliability. If it's reliable, the question is, what are the inferences to be drawn? If the inference to be drawn is incriminating, then it goes into the frame of the evidence that the court will consider. It will be wrong, my lady, to put everything in the mix, and this is how I read my learned friend's argument to a large extent.
Because that is what I think the reported decisions say, that you take a lot of gossamer threads and together they make something that is so substantial that you can't get through it. You do not use separate incidents. This is a holistic assessment.
But you can only take reliable evidence. So if Mr. Gray's identification is not reliable, it does not go into the frame or into the mosaic, as it's been termed, in other matters. So your ladyship has to critically evaluate each component, make a determination as to what is reliable, and then decide in terms of inference, whether that is something that supports the inference that's sought to be drawn, and then put that in the framework. And my submission is, and I say it with respect to my learned friend, that the state approach, to a large extent, has been to put everything in the mix and argue the probabilities. And we submit that such an approach would be misdirected. If I may refer your ladyship to one of the authorities in the bundle that I handed up this morning, and it's the Judgment of State and Mbule.
Sorry, you want me to look at Mbule?
Yes, if I may, just briefly, my lady.
Reading what is in front of me.
It's page 68 of the, I've cited it in my head, but I want to refer to further aspects.
Yes, thank you. Page 68.
Paginated 68 on the top right-hand side. The SCA judgment, my lady, where Justice of Appeal Nugent said the following as to the assessment of evidence. This is at paragraph 57. It's tried that the state bears the onus of establishing the guilt of the appellant beyond reasonable doubt, and the converse is that he's entitled to be acquitted. There's a reasonable possibility that he might be innocent. In State v. van der Meyden, which was adopted and affirmed by this court, I had occasion to reiterate that whichever form the test is applied, it must be satisfied upon a consideration of all the evidence. Just as a court does not look at the evidence implicating the accused in isolation to determine whether there is proof beyond reasonable doubt, so too does it not look at the exculpatory evidence in isolation to determine whether it is reasonably possible and that it might be true. And there's reference to, in a similar vein, the following was said in Meshepe and others. The question for determination is whether, in the light of all the evidence adduced at the trial, the guilt of the appellants was established beyond reasonable doubt. The breaking down of a body of evidence into its component parts is obviously a useful aid to a proper understanding and evaluation of it. But in doing so, one must guard against the tendency to focus too intently upon the separate and individual part of what is, after all, a mosaic of proof, and this is what your ladyship was alluding to. Doubts about one aspect of the evidence led in the trial may arise when that aspect is viewed in isolation. Those doubts may be set at rest when evaluated again together with all the other available evidence. And this is the important part, my lady. That is not to say that a broad and indulgent approach is appropriate when evaluating evidence. Far from it. There's no substitute for a detailed and critical examination of each and every component in the body of evidence. But once that has been done, it's necessary to take a step back, a pace, and consider the mosaic as a whole. If that is not done, one may fail to see the wood for the trees. And I emphasize, my lady, the need for a detailed and critical examination of every component in the body of evidence. And if your ladyship, for example, undertakes a detailed and critical analysis of the identification evidence of Mr. Gray, in our submission, your ladyship will reach a conclusion that it's not reliable evidence, and therefore it cannot form part of the mosaic. Equally, a separate, detailed evaluation of the evidence of Mr. Thomas, bearing in mind the cautionary rules, bearing in mind the caution with identification generally, the irregularities in the context of the identification parades, the values, the fact that a doc identification is tantamount to asking a leading question. Factor all of that in, my lady, and decide what can form part of the ultimate picture that the court has to assess. It's not a question of saying, well, that evidence is there. It wasn't good evidence. It wasn't particularly reliable evidence. But weight can be attached to it because if it's read with something else, it can be elevated to that status. That would be a misdirection in our submission. If evidence is not reliable, it remains unreliable, and weight cannot be attached to it. We make the submission, my lady, that on the basis of a fair and proper analysis of the evidence that we have tried to take your ladyship through, including the significant exculpatory evidence which is common cause, that the state has fallen far short of proving the guilt of the accused beyond reasonable doubt on either of the charges. What the state has done is no more than create atmosphere and argue probabilities in an effort to point a finger of suspicion at the accused. We submit this fails to meet the standard of proof required for a conviction. And it's submitted that a proper analysis of the evidence shows the version of the accused to be reasonably possibly true. And even if your ladyship has difficulty with the accused as a witness and decides not to accept his evidence, it doesn't relieve the state of its burden of proving the proof beyond reasonable doubt. A line can be drawn through the defense case if needs be. We're not submitting that that should happen. But if a line is drawn through the defense case, the question remains, has the state proved its case beyond reasonable doubt? And then again, my lady, go back to critically evaluate the individual components of the evidence, decide which is reliable, and decide which can be factored into the overall picture. We make the submission respectfully, my lady, that the accused is entitled to be acquitted and discharged on both counts.
Thank you very much, Mr. Webster.
Thank you, my lady.
Are you ready to argue now?
I am ready to argue now.
Very well. Otherwise, I was going to say that we can also hear you shortly on Monday.
I'm fine, my lady. Some of the aspects I prepared to address the court on board is already alluded with Mr. Webster, but we'll go quicker. I must just, my lady, because in terms of the Criminal Procedure Act, at this point in time, reply is only allowed with regards to questions of law.
Yes.
May I ask with leave of the court to also address the court on questions of fact?
I want to hear what Mr. Webster says about that, but it certainly will assist me.
Subject
As
if
there were
necessary.
questions that I've asked that were replied to that maybe would assist the court in making...
I have no difficulty, my lady, save for the fact that we might in turn ask to address certain questions of
Yes,
fact.
of course, Mr. Webster.
Thank
I
you.
understand.
As court pleases. Firstly, with regards to the identification evidence, I start on page 2 of the reply to the heads of argument by the defense. Firstly, in terms of the authority of State v. Snyman, it's a rather old matter, 1968, is an appellate division judgment, milady. The moment the evidence of a witness is corroborated in some way whatsoever, they can, strictly speaking, no longer be considered a single witness. It is the State's submission, milady, given the cell phone evidence and the other corroborating evidence as alluded to in our argument previously, neither Mr. Gray nor Mr. Thomas can, in the strict sense of the word, be regarded as single witnesses. Furthermore, with regards to the reliability of specifically Mr. Thomas's identification of the accused as the driver of the white Audi at 9:30 that evening, the defense in their heads and arguments concede that Mr. Thomas had a very good opportunity to observe the driver of the white Audi. But in alternative here, with regards to the single witness, if this court is of the view that the witnesses are indeed still single witnesses with regards to identification specifically, it is submitted that the Corsnell test in that regard has been met given the corroboration for their evidence. The shortcomings of the photo identification parades.
And the corroboration, you say the corroboration is another witness?
The cell phone evidence, milady,
cell phone evidence.
Even evidence, the circumstantial evidence. The accused admitted or conceded that the dark green BMW visible at all times during the course of that day is indeed that of the deceased. Then if one goes to the probability of his version, the improbability thereof, it is submitted, at the very least, supports the evidence of the witnesses in the sense that it was the accused who was driving the motor vehicle. I can refer the court also to pages with regards to the specific detail, pages 35 to 38 of my heads of argument in chief, milady, where I address the aspects that corroborate the different witnesses' evidence. Specifically, with Mr. Gray, page 36, the vehicle is driven by what appears to be a white male in the morning. That afternoon, still driven by what appears to be a white male. In both instances, the white male resembles the accused in stature. The identification is corroborated by the cell data of the accused's phone. The person whom Gray observed has enough of a resemblance to the accused that he can make a mistaken identification, and the accused places himself in the vicinity of both these scenes. Lady, that is one of the further aspects that is listed in Matetwa's case, is what the court needs to take into account when you consider identification evidence, is whether there is corroboration for the identification. With reference to the shortcomings of the photo identification parades, with reference to the case law, as I've already referred the court to State v. Bailey, it is submitted that the aspects raised in pages 7 to 18 of the defense's arguments cannot be described as irregularities per se. At most, it can be described as imperfections. If I can refer the court to paragraph 33 of State v. Bailey, which I also quote in my heads of argument, Mr. Justice Griesel quotes from Rex v. Kola when he says that, of course, an identification parade is not necessarily useless because it's imperfect. In some respects, the quality of the parade must necessarily be a question of degree. No aspect of there being irregularities in the parade. And it is found, Mr. Justice Griesel confirms the opinions or the judgment of Rex v. Kola that each case must be decided on its own merits. and it is submitted, my lady, that any imperfection in the setup and execution of an identity parade may have an effect on the weight the court can attach to that evidence. Then, in considering the weight and the imperfections pointed out by the defense, my lady, firstly, the fact that the witnesses were together on the way to Hout Bay and together in the waiting room, there is no evidence on record that they discussed the appearance of the accused. Mr. Gray's evidence was, yeah, we had discussions, we talked about that, we're both witnesses, where we come from, never anything that they discussed the appearance of the accused or the person they're supposed to identify. Mr. Thomas was more, his recollection was better than that of Mr. Gray, and he said, yes, we had discussions, but we never discussed the appearance of the accused or the person we're supposed to identify. And with all due respect, my lady, that is what is attempted to be curtailed, the possibility of that occurring, why the witnesses should not, in a perfect world, be together. Sergeant Sonnenberg testified, my lady, there's only one vehicle at the Diep River police station. That's why he had to drive the witnesses there himself, and he had to drive them together. Again, something that the court has already alluded to in the defense's argument, my lady, the time indicated on page 2 of 8 in both exhibits Q and S, the identification parade forms, it does not refer to the time it actually took the witness to point out somebody, but to the total time it took the member to complete the papers in related to the identification. And I refer your ladyship to the record, page 265, line 16 to 266, line 15. It's the evidence of Constable Taba.
You will recall that is exactly what I put to the...
Yes, ma'am, indeed. And then Sergeant Sonnenberg advanced reasons for why it was not a living person identification parade. My lady, whether the defense accepts that or not, that were the circumstances that Sergeant Sonnenberg was faced with. He did the best under the circumstances. He compiled a photo identification parade, and it is submitted with all due respect that a period of 7 weeks is not a substantial period of time given the obstacles that the investigating officer faced in this regard. And both witnesses were, this is already something that the court also alluded to, they were honest with regards to the possibility of seeing the accused in the media before the identification parade. I refer the court to footnote 32 of my heads of argument with reference to the witness Gray. He testified that he does not buy newspapers. He does not recall seeing any photographs on social media except the clip about the missing person. And he does not concede that he may have seen an image of the accused on Facebook as the accused is, he concedes that he may have seen the photograph of the accused on Facebook as is included in that photograph. Footnote 34 of my heads with regards to the witness Thomas, he testified that he does not read newspapers, he's not active on social media, and the only photograph he did see was the one that was shown to him to take note of the woman who died on the scene. His evidence was, as the court has already remarked, was that he immediately then recognized the accused as the person he'd seen with the Audi. Lady, again, with regards to the witness not seeing a photograph, or when one considers the rules of practicality with identification parades, it refers to that the witness not be shown a photograph. It is submitted that an intent of forewarning the witness about the identity of the person that he or she has to point out is intended there. One cannot, with all due respect, in today's age, expect of a witness not to possibly see some picture somewhere of a person, an accused person in the media. Now, it's submitted that in total, the setup and execution of the identity parade, although not perfect, was fair, objective, and independently done. It is furthermore submitted that both the witnesses, Gray and Thomas, showed an earnest grasp of the proceedings and the fact that they needed to point out the correct person. As has been remarked by the court during the arguments for the defense, Mr. Gray's clear aspect that he wanted to make it clear to the court that there was somebody else who looked similar to the accused and the person he identified earlier. It is submitted, my lady, in the end through, as referred to by the defense, the 3 points during the process of identification. The witnesses were consistent in their identification of the accused as the person they observed during the relevant times. With regards to the arguments around the accused alibi defense, lady, it is submitted that the accused did not supply a detailed information regarding his movements during the course of the 22nd of February 2018, early on in the matter. In Exhibit J, he makes no mention of his movements other than to say, I went to work, while in Exhibit K, he provides a version of being out looking for a vehicle. Then when one considers the content of Exhibit J, in conjunction with the evidence of Nicola and the telephonic requests to Van Rensburg, it is submitted that these 2 versions are indeed mutually destructive. He was either at work or he was looking for a vehicle. It is submitted, my lady, that as the accused's cell phone was turned off at that particular time, it's argued that the accused does not have an alibi for that relevant time, and thus the reason for the call to Van Rensburg. The same circumstances and arguments are applicable, my lady, to the events at 2 o'clock and 9:30 of that day. It is submitted, my lady, that there is no evidence to support the accused's alleged alibi that morning as was presented. The cell information, the submission that the accused did not at the time of drafting exhibits J and K knew that there would be cell data, and yet the information fits with his version, thus corroborating his version, does not with respect hold water. The accused knew very well where he had been driving during that day. It is not difficult to attribute an exculpatory explanation to those movements subsequent thereto. Something that I did not add here to Milady, it was also argued that the accused would not have made calls to the deceased phone had he known that she was already dead, Milady. If one has regard to the fact that he only made 2 calls on that day, and the one call shortly before he arrived at work, and the second call shortly before or after he left work. Those were the only 2 calls during the day that he says he was looking for his wife. Just the day before, the 21st of February, there were 5 calls between the accused and the deceased. 1 that she made to him, the other 4 were actually the accused calling the deceased. With regards to the aspect that Warrant Officer Harvey's evidence and interpretation of the cell phone evidence corroborates the accused version, lady, if one has a look particular to the issue that was described, Exhibit CC at 15:18 on the 22nd of February 2018, where the column with the heading Other Party or Comments, it is indicated, by Warrant Officer Harvey that the accused arrived home. During his evidence in chief, when the witness testified with regards to how it came about that he compiled Exhibit CC, he testified that that column contained information relating to his own comments. I refer the court to the record, page 32, lines 18 to 22. There is no evidence by Harvey that when the accused left or arrived back in reference to the 2 drives that he undertook, that he indeed started and or ended the drives literally from his home. It was asked in chief of him that you are merely trying to indicate in which area the phone was when those particular calls were made. And therefore the accused was cross-examined on that aspect, that were you actually at home or not, and it was dealt with in my short argument, paragraph 9.4, on page 13 and further, where I dealt with a summary of Warrant Officer Harvey's evidence and then went into detail with regards to the specific cell phone and the movements of the accused. And I would like to refer the court specifically to page page 20, the third paragraph thereof, where I argued and referred the court to footnote 21 on page 20. Upon a consideration of the evidence at instances when there is some corroboration to the effect that the accused was actually at home, the only towers that register his cell activity is the Constantia Dale or Lower Constantia Towers. With regards to the accused's personal phone, milady, it was the accused's own evidence that he did not carry that phone with him at all times. In actual fact, he testified that he hid it at different locations in his house so that his wife could not get hold of it. So even though the phone was switched on, it was not with the accused necessarily. And that phone also has barely any activity recorded, which seems to support that. Now, with regards to the investigating officer as a witness, it is submitted that the investigating officer was not selective, nor did he target the accused. When one considers his evidence, upon obtaining evidence that clearly implicate the accused in the commission of the crimes, it's difficult to understand how the subsequent following of this evidence can be considered to be an intentional and supposedly malicious targeting of the accused as a suspect. The information related to the possible witnesses, and I refer to Mr. and Mrs. Stewart and the occupants of number 5 Lucius Way, were followed up, but as they provided no information relevant to the matter, no statements were obtained from these persons. Ladies, with all due respect, the fact that the witness did not hear or see anything related to an alleged crime does not in any way imply that the crime was not committed, nor is the police obliged to obtain statements from someone who, as a result, cannot take the matter further, either in the guilt or the innocence of the accused. The accused similarly testified during his evidence, milady, that he himself does not know the people who reside at number 5 Lucius Way, and he cannot provide any reason why they would be interested or have any connection with his wife's vehicle. In general, milady, the submissions made on behalf of the accused that the evidence of Ms. Markle, Harvey and the cell data corroborates the version of the accused is based on the timeline as indicated by Mr. Thomas in his statement, Exhibit T. This witness qualified this during his evidence in court to say he was not sure of the time, but that Govender was. I refer the court to the record page 211, lines 7 to 25. Govender places the events at 9:30 that evening. And I refer the court to the record page 193 to 194, where he says, I actually looked at a clock before I left the house. The accused's sister testified that he left her house at 9-ish, according to the record, page 282, lines 15 to 20. Therefore, the argument earlier, milady, that by 9:18 the accused might very well have left his sister's house already, and that might have just been the last recorded call under that area of reception for that tower. Milady, it is submitted that upon a consideration of all the relevant evidence, the argument that the accused version is corroborated by the state's case is with respect far-fetched. In conclusion, milady, it is submitted that the accused should be convicted as charged. Those are my arguments, milady. Anything else that the court would like to?
No, thank you. The questions that I wanted to ask you have dealt with.
As
My situation is that I have a trial next week, a criminal case where there's evidence led regarding to sentence and a probation officer report and so on and so on. I obviously need some time to go through the documents again and your arguments again and prepare a judgment in this matter. And Wednesday's a public holiday. I think I should be able to safely say the 14th of May, 13th of May, 14th of May as a date that I should be finished. I must add that if by that time I find that I've not been able to finalize anything, it will have to be the matter will have to be postponed, but I think I would like to give myself sufficient time to finalize the matter. Would that day suit the two of you if I make it the 14th of May? Yes, of course you may. Would you like the court to adjourn and come back and you can discuss this?
Just very
particular
briefly, if we
aspect?
may.
As I say, the 13th is a Monday, the 14th is a Tuesday. I just thought that maybe, depending on what my internet situation is and email situation is and typing situation is, I want to give myself the Monday to finalise a judgment.
So Tuesday the 14th is the
Tuesday
date.
the 14th is the date that I suggest, but I'm available to discuss alternative dates. Court
Thank you,
will
Lady.
adjourn for 5 minutes or 10 minutes. With the legal representatives in my chambers, we have agreed on the date of judgment to be on the 16th of May at 10:30 in the morning. So the matter is postponed to the 16th of May at 10:30, and the accused will remain in custody until that date, and I will see you then.
As the court pleases, Madam.
Thank you. The court will adjourn.